All right, thanks so much for that, Rachel. We're actually going to hear from Rachel again because we have an all-new trial that we're starting hopefully tomorrow. Jury selection right now is going on in Iowa versus Cheyenne Harris. Now, a few months ago, we covered the trial of her boyfriend, Zachary Keene, who was convicted of first-degree murder of their infant son, Sterling. Now, Cheyenne, the mother of that young infant, is on trial for the murder of little Sterling and child endangerment. So let's hear from Rachel Stockman of what's going on with that case.
A young Iowa mother faces first-degree murder and child endangerment charges in connection with the death of her 4-month-old baby, Sterling Keene. Sterling was found dead and covered in maggots in his baby swing on August 30th, 2017. Authorities say the baby had not had a diaper change, bath, or been removed from the seat in over a week. The parents, Zachary Keene and Cheyenne Harris, are charged with baby Sterling's death. Authorities first responded to the home that morning after Keene called 911.
And she come in, looked me up and said it's gone.
Okay. Cheyenne did it?
Yeah. So I got on the phone and called y'all right away. So I was a little disorientated and then woke up and told my son's parents.
He claimed the baby was fed at 9 a.m. that morning and was in good health. But when they checked on him just a few hours later, he had died. The medical examiner ultimately ruled the death as a homicide caused by failure to provide critical care, after an autopsy found maggots in various stages of development on the infant. The baby also had an extreme diaper rash and caused E. coli to enter into his bloodstream. Zachary Keene testified at his trial in November, which we showed here on the Law&Crime Network. He said that Harris was the primary caretaker of the child. Keene was ultimately found guilty after about an hour of jury deliberations and sentenced to life in prison. He is now seeking a new trial. If convicted, Harris also faces life in prison, the mandatory sentence for first-degree murder in Iowa. I'm Rachel Stockman for Law&Crime Network.
All right, thanks so much, Rachel. It's been a busy day in the Cherkasky home. Joining me now is trial attorney Katie Cherkasky. Of course, your husband was just on with us in the last hour. We want to talk about this Iowa case here. Cheyenne Harris, she's going on trial for the murder of her infant son, Sterling. Now, her defense has already claimed that they're going to use an intoxication defense because she's saying that about 3 weeks before, she was still using meth. Now, her boyfriend at the time said he had used maybe 2 months ago, but the defense is saying, hey, we're going to use the intoxication defense. Do you think that will go over well with the jury here?
I think that it's going to be very difficult for both of them to really get any sympathy from the jury, regardless of the defense. There's been very inconsistent statements about the timeline. Obviously, the forensic evidence has shown that the child was neglected for a very long period of time. Mm-hmm. Way more than what they had originally suggested. So I think that any attempt to mitigate the charge with an intoxication with meth is probably not going to play too favorably for them. But you have to put on some sort of defense, and so that's one strategy.
Yeah,
I don't think it will ultimately change anything.
Yeah, I think you're right. But of course, Zachary Keene said that Cheyenne Harris was the primary caregiver of their young son. So I'm curious to see how that will go when this trial starts. Again, jury selection is going on right now as we speak. We expect that trial to start tomorrow. Of course, we'll cover it here on the Law&Crime Network. But, of course, we're covering the Charles Merritt murder trial. And we want to take a listen to the 911 caller who found the bodies of the McStay family in California. Let's take a listen.
Hi, I'm out here on a motorcycle out behind the dump, and I found what looks like a human skull.
Can you give me a location?
Yes. Okay. West of the 15 and north of the stockpile where the dump is. Maybe I should just call the local sheriff and tell them where on a map, because it's all dirt roads.
I understand, but I'm just looking for a starting point. And this is the local sheriff.
Oh, okay. Starting point. Start at the 15 north Starterwell exit.
Okay. Let's see, is it over by the landfill?
Yes. It's within, I'd say, about a half mile of that landfill. It's directly to the south of me.
Okay, so from the landfill, where are you?
Due north, approximately, I'd say a good 2,000 feet.
Okay. Did you find it in the landfill or just in a field out there near it?
All right, so that was John Bluth. He actually discovered the bodies of the McStay family there in the desert in California back in 2013. But Katie, I got to ask here, so we have no confession from Charles Merritt. Where do you think we would be had Mr. Bluth not stumbled upon those bodies? Do you think that the theory would still be that they went to Mexico and that was the end of it?
I think that's a really good possibility. The only real evidence connecting Charles Merritt is the cell phone tower pings close to the grave sites that were obviously very well concealed, according to that testimony, very difficult to find, and it worked for quite some time. But yes, the discovery of the bodies really was the beginning of the linchpin of the case at all. Without that, I don't think that they would have gotten this far at all.
Right. Now let's talk about the cell phone ping here for just a second, because from what I understand, the location where the bodies were found were not too far from Charles Merritt's sister's home. So from a defense standpoint, I could say, well, hey, yeah, of course my client's cell phone's pinging in that area because he has family that lives in the area. What say you?
Well, of course, and there's going to be an explanation that's offered about why he could have had a cell phone tower ping in that area. Is that enough to overcome the coincidence on top of everything else that the prosecution has? I don't know. I mean, it's a matter of things piling up on top of each other. So can he corroborate that? Can that be something that they have evidence to put forth to the jury? I think that is going to be what they need to do. And sure, that may be enough, but it is a very bad coincidence for him, if nothing else.
Yeah, so do you think they'll call a cell phone tower expert, if you will, to the stand to talk about that?
Absolutely. They're going to need an expert to discuss the accuracy of these findings and to talk about specifically how they determine whether somebody was in a specific area, how close that was. Was it really close to his sister's house, or was it just closer than his house is to that gravesite? I mean, that's going to be very critical information here. And of course, they are going to offer some explanation or try to cut the expert's testimony down on credibility, but that's going to be very difficult. That kind of testimony can be very damning. Yeah. And I think in this case is critical.
Absolutely, Katie. We're going to take a quick break. Again, Charles Merritt is on lunch. As soon as they go back live, we'll go back into that courtroom. Stay tuned to the Law and Crime Network. You don't want to miss it. Charles Merritt on trial right now for the murders of the McStay family. We'll be right back. Back to the Law and Crime Network. Again, Charles Merritt, that trial is on lunch. Right now, we're going to hear previous testimony from the medical examiner. Again, the entire McStay family was found in the desert with blunt force trauma. Let's go to that testimony.
Mostly all the bones are white, rich, and dry and flaky. There's some brown discoloration on one of the rib and top of the bones.
And moving on to the actual next exhibit, which would be 351. Did you find anything significant about this particular portion of the skull that was remaining?
On this frontal bone, we see a circular or half a circle defect on the back right side. The cause of this is unknown. There's also a fracture or broken piece of bone here on the right side, and this fracture determined to be not hernia.
Right, what's depicted in this photo?
This is the skeletal inventory of Cheyanne, starting from the skull on the right side of the picture down to the long bones on the left side of the picture.
When you received these remains, were they also in a sealed box?
Yes.
And so when you received this sealed box of bones, because these have significantly more than the other autopsy that we just looked at, how do you determine what goes where?
It is determined by Dr. Gray.
So you're only doing one autopsy at a time, is that correct?
Correct.
And so the bones are taken out. Is she the one that places them in position?
Correct.
Okay. showing you what's been marked as People's Exhibit 355 for identification. Can you describe what we're seeing in this particular exhibit?
Can I look at the picture, please?
All right, so that was previous testimony from the medical examiner. Now, you heard her talk about a half-circle defect and some fractures to the skull, but then you saw actual bone fragments of the little kid. Gianni's body was there on the screen for the jury to see. Now, Katie, I got to tell you, as a parent, if I was sitting in that courtroom and you can see that there on the screen, I think that would hit me pretty hard to see such little fragile bones, just what remained of such a little innocent kid in this case. I think that's going to weigh heavy on the jury. What say you?
Absolutely. It's a really tragic case, very gruesome details. And I think that what's always been interesting to me is the motive of Charles Merritt that the prosecution has presented doesn't go far enough necessarily to explain why the whole family had to be killed in such a gruesome manner. So I think it cuts both ways for both the prosecution and the defense to me, because it's awful to see that, but it's also interesting from a defense perspective.
Right, and you made a good point. Why the entire family? So if the beef, as the kids say, was with Charles and Joseph, why not just Joseph? Why the entire family, and why such a brutal way to commit these murders? You would think, if it was about money between the two, that, hey, maybe Joseph would be shot and, it would look like a carjacking or a robbery gone wrong or something like that. But why the entire family?
Right, exactly. I think that's always the question that's been weighing on my mind. And I don't know if the prosecution has presented anything to really go so far with that. They don't necessarily have to, but I think that's a question that is begged by this evidence.
Well, they don't have to, and maybe they will as we go along. With that, let's hear more testimony from the medical examiner.
Top of the skull, again, you see the same half-circle fracture here on the left frontal bone, and the area that was dark in the picture is actually this area, the left backside of the head, also looks like a half circle. And you can tell that even though there are no bones in this area, that there was a impact here because of this piece of skull. It's triangular shaped with a circular base that is broken but still attached to it. You also see another fracture here on the sutures, which connects the two bones.
And moving on to Exhibit 353, can you tell us what's depicted in this photo?
In this photo, you're looking at the left back side of the skull, and you're getting more of a clear look of the circular shaped fracture with the still attached broken bone.
And moving on to Exhibit 358, if you can tell us what's depicted in that photo.
So for orientation, the front of the skull is missing. You're looking at the top of the head, and the base of the skull is here on the table. You see that same curvilinear fracture here in the left parietal, but in this photograph you see another fracture that has a curved line. This fracture resulted in the fracture in the suture. It also radiated outward towards the left side. And on the right parietal bone, you see an impact here causing a linear fracture coming up to the fracture on the top of the head.
And moving on to Exhibit 359, can you tell us what's depicted in that photo?
In this photo, you're looking at the right side of the head. For orientation, the right side of the photo is the front of the head, and the base of the skull is facing the ruler. And you're looking at the fracture of the broken skull on the right side of the bone.
Is there anything significant with respect to the discoloration that we see in this photo?
The discoloration is...
Now, are you able to determine exactly how many impacts or strikes caused these injuries?
Because there's no soft tissue on these bodies, you can't tell exactly how many impacts, because you can have a force put on you, on your head, that doesn't cause skull fractures, and it only causes either bruises or the scrapes or laceration, as we talked about. So those are also impact site. So on these cases, I can only say what's the minimum amount of blows to the head that was found based on the fractures that we see on the skull.
And what would that minimum number be?
For this case, the minimum...
All right, so more pretty graphic testimony there from the medical examiner in the McStay family murder trial. Charles Merritt on the trial for those murders. Katie, I got to ask, though, because, you know, she talked about the blunt force trauma. You saw the injuries there to the skull. The sledgehammer being recovered where the bodies were recovered. To me, and, you know, I've never bludgeoned anyone to death, but I think I would be smart enough not to bury the murder weapon so close to the bodies, especially even in 2010, everyone knew about DNA and things of that nature. There's no guarantee how soon the bodies would have been found. So the fact that that sledgehammer was so close to the bodies has always troubled me. Do you think Charles Merritt would have been silly enough, dumb enough to do something like that?
Well, that's a good point. I actually think that the bodies were very well concealed, given the fact that it took years to locate them. So maybe he really thought that this was all just a good place to dispose of everything. I think it was still a bad decision, as it turned out. But, yeah, it's an interesting issue for sure.
Yeah, it's very interesting because, yeah, to your point, it did take 3 years to find them. But, you know, by happenstance, this guy riding his motorcycle just happened to come across these two shallow graves, if you will, to find them. So that could have happened, you know, in my opinion, that could have happened a day after they were placed out there, a week after. Didn't necessarily have to take 3 years because obviously this guy's riding his motorcycle. We can assume other people ride their motorcycles out there as well. What say you?
I think that maybe tells us things weren't necessarily as planned out as they might have otherwise been. That could be one indication of why that took place in that manner. It might tell us how the murders took place, where it happened. I know there's a debate about whether it was in the home or really near the grave sites. And I think, to me, it kind of cuts to the idea that it all happened probably out in the desert, and maybe it was in a rushed fashion. Maybe there was a concern that people would be stopping by and he didn't want to transport the murder weapon to another area. I think there's lots of different explanations, but I also think you can cut it the other way, like I said earlier, that, hey, he thought this was a great hiding place, and so he just figured he'd get rid of everything there and then just be done with it and get out of there. So,
yeah, and maybe it was a hiding place, or maybe it was the actual site of the murders. Maybe for whatever reason those bodies, or the McStays at the time, were somehow lured out there, and that's where it occurred. Because again, the prosecution says it happened in the home, but we heard previous testimony where that investigator said there was no such evidence. We're going to take a quick break. Again, we're waiting for that courtroom to go live in the Charles Merritt murder trial. As soon as it does, we'll get back into that courtroom. Until then, stay tuned to the Law&Crime Network. Welcome back to the Law&Crime Network. Of course, we're covering the Charles Merritt murder trial. There's so many theories in this case here that the McStays were killed inside the home. The defense says that Summer was sexually assaulted, and they actually say someone else, a former business partner, Dan Cavanaugh, actually killed the McStay family. But, of course, cases come down to evidence. So let's hear more testimony from the medical examiner in this case.
Now, could an injury like this occur without there being any actual blood that comes out on the outside of the skin?
Yes.
How could that occur?
Because you will have blood coming out of the skin if there was a laceration, an open wound. With a trauma like this, you're definitely going to have external injuries, but it could be a bruise or an abrasion. It doesn't have to be a laceration.
How How about some of the other fractures that we looked at with respect to Summer McStay? Is it possible for those injuries to have occurred without external lacerations?
Based on the number of pieces of skull that are broken, you would expect that there would be some lacerations, but not all of the skull fractures need to have an overlying laceration.
So is it possible that you could incapacitate somebody to a certain degree, because you can't tell us how many of these fractures occurred at one time? Is it possible you could incapacitate somebody to a certain degree without causing a laceration to the skull with blunt force trauma?
Yes.
If she was raped?
No.
What type of evidence would you need actually to determine whether or not a rape had occurred in terms of tissue?
In terms of tissue, you want to see if there's trauma to the soft tissue of the vaginal area.
And because there was no tissue attached, you cannot make any medical determination that that occurred. Is that correct?
Correct.
Were you able to determine the cause of death?
Yes.
What was that?
Multiple blunt force injuries to the head.
And were you able to determine the manner of death?
Yes.
All right, more testimony from San Bernardino medical examiner. Katie, I want to touch on something here. She said you would expect to see lacerations. So when I hear that, is she saying that maybe there would be blood, but not a lot of blood splatter? Because that's what we're looking for. That's what the jury's looking for, to say that these murders occurred in the home, this blood spatter. So is she saying with that statement, well, you may see lacerations, but maybe not just a lot of blood spatter as you would expect?
Yes, exactly. I think that they were getting to the point that it's possible to cause severe injury without having severe blood splatter, which is something that the prosecution needs to explain because of the lack of evidence in the home. The theory about where they were killed has to take on some form, because if they were killed in the desert, then how were they transported there? There has to be some solid theory about how this happened. So I think that was what the testimony was getting at, is that it is possible to cause that sort of injury without having significant blood splatter.
Yeah, and I've seen it personally in my days in policing. I've seen people with fractured skulls, and you just really didn't see a lot of blood, or if any blood at all. So it's not unlikely that, yes, they were bludgeoned, but there wasn't a lot of blood inside the home, and, you know, hence the question, did it really occur there or not? So let's talk about this sexual assault, if you will, because that is something that we've heard, that Summer McStay was sexually assaulted, but without a rape kit, without the soft tissue to see if there was trauma to the vaginal area, there's no proof of that. So again, we're here on a theory, on a narrative that we can't really prove.
Right. It's interesting. I think a lot of that narrative is based on the idea of how the underwear was found at the gravesite. Mm-hmm. But obviously, there's not going to be any way to prove rape. I mean, even if you have soft tissue, there's not necessarily a determination fully of whether a rape occurred. There's indications of trauma to the vaginal area, but that's not something that is ever 100% proven by physical evidence. But here we have absolutely no physical evidence of that. There is the state of the underwear, which I think is the basis for that claim. And it's not something that's going to be able to be proven one way or the other at this point.
Right, absolutely. Now, we heard from the medical examiner in this case, but earlier today we heard from a Joseph Steers, who is a former investigator there in San Bernardino County, who did a search warrant 9 months after the McStays were found inside their former home. Let's listen to his testimony.
What stood out to you as an initial investigator evaluating the state of the investigation when you saw that photograph?
And that there were no towels inside the bathroom.
And is this the downstairs bathroom?
That's correct.
Exhibit number 100. Is that the upstairs bathroom?
Yes, the upstairs shared bathroom.
And what was significant about that photograph when you reviewed it?
Again, no towels.
Exhibit 660 in the top left. That is what?
That's the master bathroom. And there's one hook with no robe, and then a second hook with a bathroom on.
In the bottom left, exhibit number 53, what is that?
That's the downstairs bathroom toilet, where there's a decorative rug chamois on the toilet seat, and no matching floor rugs or any other type of matching set to it.
Did that cause you to look at the evidence that was recovered from the grave sites?
Yes.
Showing you exhibit number 297 as displayed. What was significant about that?
Looking at the fabric and the way it's depicted in the photograph, it appeared consistent with what would be either the bathrobe, if there's one missing from the hook, or from matching rug to the toilet seat cover.
And 293, what was significant about that?
293 appeared to be a towel with the sunflower type print, consistent with a bath towel over beach towel, which I did not notice in any of the other photographs of the residents at the time of search warrant.
Now, the fabric material, fuzzy fabric material 297 and in the town 293, those were not the exclusive pieces of evidence taken from the grave that piqued your curiosity, was it?
No, they weren't.
There were other pieces of material found, to your knowledge?
All right, previous testimony from Joseph Steers, former investigator there in San Bernardino. Katie, I want to touch on something here. He talked about there were no towels in the master bathroom there. You saw the picture. Now, does this suggest that maybe those towels were either A, used as part of a cleanup, or B, actually used to maybe wrap around the victim's head so that if blood did come out, it's already in the towel. You won't have to worry about blood spatter, and you can just discard those towels after you dispose of the bodies.
Yeah, I think that's absolutely what they're trying to get at. They do have to explain the lack of blood spatter, like we talked about, and that would be a very valid explanation of that. And again, that also helps the prosecution with the theory of the bodies or the people being transported one way or the other from the residence directly to the desert location where they were found. So it's another piece of information for the jury to consider. I mean, there's no way that we're going to know for certain what the towels were used for or whether there were towels in there to begin with, but it does give some explanation for those issues.
Right. Now, there was also talk about this rug that matched the toilet seat cover that was not found at the home that I believe was found at the gravesite. So it looks like the prosecution is starting to paint the picture that, yes, whatever happened here in the house, and maybe since the rug was missing, it would appear to be recovered at the gravesite, and these towels are missing, that maybe, yeah, it happened here, and maybe those towels were used again to cover up that the blood spatter. What say you in this case?
That's very possible, and I'm not sure if I'm aware of the blood or lack thereof found on the towels at the gravesite. So I think that would be a big question. But yes, I think that tends to support the theory that they were killed in the home and then transported and wrapped up in these kind of towels and rugs from the residence. That makes more sense than taking them with live people to the gravesite, because there wouldn't be necessarily any reason for that. So yes, I think that helps the prosecution's theory in that respect.
Right. Now let's hear more testimony from this Joseph Spears.
It's a picture of a beige woven cloth material consistent with what was pictured in the previous exhibit number 93 and the photographs that were seen of the futon that it had its cover on.
Check the foundation. Exhibit number 262, is that the sole and exclusive picture of fabric material taken from the excavation site?
No.
Was there numerous?
Yes.
Okay, so at this point it's an exemplar, just a single reference. Exhibit number 48 and 83. Do you recognize those two photographs?
Yes, I do.
How are you familiar with those?
These are photographs that are reviewed again from the San Diego Sheriff's Department. They served a search warrant at the McStay residence in Fall River.
And why did you single out exhibits 48 and 83 in your evaluation of the case at that time?
There's presence of paint cans in 48 on the bottom right corner, along with some painting supplies above it. And in 83, in the garage, there's a couple paint cans depicted on the right side.
And what is that on top of the box to the left in 83? And to your knowledge, was there also another paint can documented in the house somewhere?
Yes, I believe the laundry.
Okay. Based on that, looking at exhibits number 250 and 348, I believe, if I read that right and correct, do you recognize those two items?
Yes, I do.
And how are you familiar with them?
There were photographs of some of McStay's reserve found in the gravesite and the Stanley sledgehammer found in the gravesite.
And how was that significant to you in evaluating this case in the beginning?
Both items had what appeared to be the paint smudge on them. The bra had what appeared to be paint going horizontally across it, and then there was a paint smudge on the handle of the Stanley sledgehammer. And those are consistent with the painting at the residence in Fallbrook.
Objection, foundation.
Are you aware whether the hammer and the bra, what appeared to be paint, was sampled and sent off for further testing?
All right, we were looking at photos that Joseph Steers took of the McStay family home and also the sledgehammer. Now, we heard testimony that some of the paint found on the sledgehammer and Summers' bra was consistent with paint found in the McStay home. Katie, let me ask this, though. It's consistent with the color. We can assume that it's the same paint and came from the same can. But do you think we need, say, someone from Home Depot or wherever this paint came from to get on the stand and testify that, yes, this is the exact formula of that paint that we sold and its number, blah, 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 to say that, yes, it is? Because, I mean, just a smudge of blue paint here and there, to me, doesn't necessarily say that it came from that home.
Right, exactly. You're going to have to put up witnesses to really nail down all of this evidence and to draw the connections, because the more that the prosecution can paint the full picture of the story, that's going to be better for them. So they're going to have to close the loops on that sort of information, including the paint. I mean, it's not enough to just say it looks like it came from here. There's going to have to be some confirmation of that.
Yeah, and if I was a prosecution, I would be looking for a paint expert. I'm sure there's plenty of those individuals that sell paint for a living, and that's what they do. They match the paint. And, of course, you can go back to the paint store, wherever you got the paint, to say, yes, this is the same chemical compound of what was sold in that can. That's something I would definitely do if I was the prosecution. Again, they say that the McStays were killed inside of their home. Will they prove that case? We don't know. When we come back, we'll have cross-examination of Joseph Steers, the investigator who did a search warrant on the McStay home 9 months after their bodies were recovered. Stay tuned to the Law&Crime Network. We'll be right back. Welcome back to the Law&Crime Network. We heard testimony from Joseph Steers, former investigator. Now, let's hear cross-examination from the defense. Refresh your memory.
Yes.
It's true you didn't quantify it with possibly in your affidavit. You were certain it would be there.
Objection, argumentative, relevance.
Sustained as true.
You were concerned that San Diego, when they were in the house, did not find any scene of a crime, so you thought it was important to go back into the house and look for evidence, correct?
Correct.
And so when you went there, you also informed, or you also wrote that, strike that. Isn't it true at your experience that if there are blood stains on a wall, even if they're painted over, it can still be detected?
It's possible, yes.
If the correct forensic process is done, you can find it, correct?
Yes.
And you went there with that intent?
Yes.
And you brought a crime scene tech with you, correct?
3 of them.
And you did search the house?
Yes, sir.
And you did find points of interest in your investigation?
Yes.
And you came in contact with the homeowner, Sandra Callahan?
Yes.
And she went through with you what changes they had made that you testified to, correct?
Her and Sean, yes.
So she said, we changed the floor on the first floor in the family room and kitchen, pulled up the linoleum and carpet, correct?
Objection, hearsay.
Yes.
Did they mention finding any blood stains in the carpet or in the patio?
Objection, calls for hearsay.
She mentioned one stain that troubled her, but she didn't know if it was blood.
Is that the one on the stairs?
No.
She said the carpet on the stairs was the same, though, correct?
Yes.
And then she pointed to different stains on the walls on the second floor.
Correct.
Not in the carpet, but on the wall.
Correct.
And you went and did testing on those, correct? With your field techs?
Yes, and I apologize. You said not on the carpet on the second floor. There was one stain on the second floor, which she pointed out that we tested.
Right. You went through and you marked them with different placards to identify the different things you wanted to sample. Is that accurate?
Yes, sir.
Placard 1 was what appeared to be to you a blood stain on the exterior of a bathroom door.
I don't know the placard number, but there was a stain there that we checked.
And you took a sample of that, correct?
Correct.
And you took that back to get tested later.
Correct.
And then at placard 2, there was a stain on the carpet on the stairs that tested positive for a hemostase.
Correct.
And could you explain to the jury what positive on a hemostase meant to you as the investigator?
A hemostase is essentially testing for any blood present at the time. So typically what we'll do is if we want to determine if it's a stain, if it appears to be blood and not hidden, we will take distilled water and put it on the hemostick or on the actual stain and put it on the hemostick, and it will react whether or not it's blood or not, and will let us know.
And so that's kind of like a presumptive test.
Correct.
And then you have to confirm that that's actually an accurate test back to the lab.
Correct.
So is it true you cut out that square of that carpet and said, we need to get the test to see what this is?
Correct.
And that was at placard 2.
I don't recall the actual placard numbers, but I can remember the site.
No, the blood stain on the exterior of the master bathroom door, correct?
Correct.
Placard 2 was on the carpet?
On the stairwell, yes, sir.
Okay, placard 3 was one where you found a positive blue star on the door frame to the southwest bathroom door.
Yes, sir, an area of fluorescence.
And can you explain to the jury what that positive blue star test meant to you as an investigator?
So, blue star is a chemical that we spray in low light or no light in areas of the mist in a spray bottle. And if there's a possible presence of blood, it will light up or start to glow. And so in this particular area, we sprayed it, and we had a glow on the area in placard number 3, which was on the west side of the door.
So that's a presumptive. You say, I need to analyze this and see if this is actually blood.
Yeah, it's an indicator for us to analyze and see.
And it looked like blood to you, right?
In placard number 3?
Yes.
I believe it was just an area of fluorescence. I don't believe you could see with the naked eye if there was a stain of blood.
Fair enough. And you took a sample of placard 3 for further analysis.
Yes, we did.
And then placard 4, down in the kitchen on the wall near the office, there was another positive hemostick detection, correct?
In placard 4?
Yes.
Yes.
And you took a sample of that as well for further testing.
Correct.
And that appeared to be on the scene. It gave the impression that it could be blood.
Correct.
And then also you took an item I-10. You took a swab of the wall near the stairs, correct?
Item I-10?
I-10.
I don't have that in my report, but I do recall that we did take a swab on the wall next to where the stain was on that placard.
All right, more cross-examination of Joseph Steers. Katie, I want to talk about this really quick. We heard the word presumptive. Of course, when you're talking presumptive, you have to go back and confirm those tests. We heard about a blood stain, or what appeared to be a blood stain on the interior door of the master bedroom and a stain on the carpet somewhere in the home. And he talked about how he cut out a piece of that carpet to actually test that for blood. But I think the bigger picture here is that blood, and is that blood of one of the victims in this case? And we don't know that just yet.
Right, exactly. And I think that is going to be something that the prosecution needs to present. Even if you can cause this sort of injury to a person without blood, there's 4 people who were allegedly killed. So the chances of no blood whatsoever in the home would be pretty difficult for the prosecution to explain, I would think. So I think it's a very interesting testimony, and it will be very important.
Yeah, don't tease me with blood and, it not be blood. But let's talk about this, though. This search warrant, again, was several months after the bodies were recovered, the McStay bodies there in the desert, as you can see on your screen. Really quick here in about 30 seconds, this was done after the house was in someone else's possession. So how big is that?
It's a big problem. I think the defense is really capitalizing on the idea that this investigation was botched, or that there was big issues with the way that they handled this, and the fact that they have other people living there and they haven't secured that scene for all that time is going to be very difficult for the prosecution to explain.
Right. Katie, stick with us. I will be signing off. Of course, Aaron Keller will be signing on here on the Law and Crime Network. He's going to resume this trial, the McStay family murder trial in California, as soon as it goes back live. I want to thank you for joining us, and I will be signing off. Stay tuned to the Law and Crime Network. So much more to come when we go back live in that courtroom in California. Charles Merritt on trial for the murder of the McStay family. Stay tuned.